If you own property in Richmond, British Columbia, what I'm about to tell you could change everything about your homeownership. Over 150 families just received letters that their $2.1 million homes might not actually be theirs anymore. This isn't clickbait, this isn't a rumor. This is a real court decision that's sending shockwaves through BC's housing market. And Premier David Eby, he's now begging the courts for help. Section 1. The Bombshell Decision. Subscribe right now because what I'm about to reveal is critical information that every BC homeowner needs to know. This could happen in your neighborhood next. On August 7, 2025, Justice Barbara Young of the BC Supreme Court made a decision that has property owners across British Columbia terrified. She ruled that the Cowichan Tribes have Aboriginal title over approximately 750 acres of land in Richmond. This isn't empty land we're talking about. This area includes private homes, industrial facilities like Canadian Tire and Coca-Cola distribution centers, Country Meadows Golf Course, farms, and hundreds of residential properties along the Fraser River. But here's where it gets absolutely shocking. The judge ruled that Crown and City titles on this land are defective and invalid. She said the government's granting of private property titles to homeowners unjustifiably infringed on Cowichan Aboriginal title. In mid-October 2025, Richmond Mayor Malcolm Brodie sent out over 150 letters to property owners. Let me read you what it said. The court has declared Aboriginal title to your property, which may compromise the status and validity of your ownership. Imagine opening your mailbox and reading that. You've owned your home for decades. You've paid your mortgage, your property taxes, your insurance. You thought you owned your land. And suddenly, the city is telling you that your ownership might not be valid. On October 28, 2025, the city of Richmond held a public meeting at the Sheraton Vancouver Airport Hotel. They expected maybe 200 people. Over 700 furious homeowners showed up. One homeowner, Cal Matu, who's owned his property for 50 years, stood up and demanded answers. You're the mayor. You're supposed to know everything going on in Richmond. I pay my taxes to you. Why did you not reach out to us? Why did you not warn us earlier? The room erupted in applause. Then Matu asked the question everyone was thinking. If I don't own my land anymore, why am I going to pay the City of Richmond taxes? Section 2. Hit that like button because we're about to dive into crucial details about what Premier Eby is actually doing and what he's not telling you. On October 20th and 21st, Premier David Eby held multiple press conferences trying to do damage control. He claimed the province tried to get property owners involved in the case from the beginning, but the court rejected it. Eby said, the province tried to have property owners served in the case, but was rejected by the court, and it's totally reasonable that owners are now anxious. But here's the thing. This lawsuit was filed over a decade ago. The trial lasted over 500 days, making it one of the longest trials in Canadian history. And homeowners are only finding out now. Here's what the BC government argued in court land lost. The province argued that Aboriginal title and fee simple private title cannot coexist on the same land. They asked the court to suspend Aboriginal title so that private ownership could continue as normal. Justice Young rejected this argument completely. The city of Richmond went even further. They argued for extinguishment, meaning Aboriginal title should be completely erased. The judge rejected that too. On October 29, 2025, the day after that explosive public meeting, Premier Eby announced the province will ask the BC Court of Appeal for ASTA of implementation. What's a stay? It means freezing the court decision while it goes through appeals. The ruling already includes an 80-month suspension, but Eby wants even more time. Why? Because he's panicking about what this means for private property across all of BC. Eby said, the ruling had been very troubling for many people in the area, including about 150 owners of private property. We're taking this case incredibly seriously. Now, here's what's interesting. BC Conservative leader John Rusted demanded that EBI take this case directly to the Supreme Court of Canada through a constitutional reference. EBI refused. EBI said a direct referral risks an academic decision disconnected from what he calls realities on the ground. Translation. He doesn't want Canada's highest court ruling on whether Aboriginal title can override private property nationwide because he might lose. Section 3. Drop a comment below if you own property in BC and tell me, are you worried this could happen in your city? I want to hear from you. Let's talk about the real consequences homeowners are facing right now. Colin Tsai bought a blueberry farm in the affected area in 2016. He spends $40,000 to $50,000 annually on labor and fertilizer. He planned to rebuild homes on the land. After receiving Mayor Brody's letter, Tsai said, "I'm translating from Mandarin here that he doesn't want to pour any more money into the land." He called the letter "shockwaves and worries." Think about what this means. Property owners can't get financing. Banks won't lend on properties with uncertain title. Home values are plummeting because buyers don't want the risk. One homeowner at the meeting said his home equity has plummeted. Remember Kalamatu's question about taxes? The city's solicitor, Tony Irachi, told him, "You're still the registered fee simple owner of your property, and as a result, your obligation to taxes continues." So, let me get this straight. The court says your title is defective and invalid. Your ownership is compromised, but you still have to pay property taxes. That's insane. Now, to be fair, let's talk about what the Cowichan Tribes are actually saying. Their lawyer, David Rosenberg, insists they did not seek to overturn private property titles. The tribes issued a statement saying, "Our case has not and does not challenge the effectiveness or validity of any title held by individual private landowners." The Cowichan Tribes say this dispute is between them and the provincial government, not individual homeowners. They argue that if private owners lose anything, they should seek compensation from BC, quote, "the party responsible." But here's the problem. Even if the Cowichan don't want to take people's homes, the court decision says Aboriginal title and private title both exist on the same land, and this must be reconciled. How? Nobody knows. The judge didn't say. Section 4. Make sure you're subscribed because this next part affects way more than just Richmond. This could change property ownership across all of British Columbia. BC Conservative leader John Rustad called this, quite frankly, the most significant court case that's ever come forward in modern history in terms of our province. Here's why he's right. Previous Aboriginal title cases in Canada focused on Crown land government-owned wilderness and resources. The famous 2014 Tl'uqtinus case. That was about Crown land. This Richmond case is different. For the first time, a court has said Aboriginal title overrides private property ownership. The judge ruled that Aboriginal title lies beyond the land title system in BC. Let me repeat that. The entire property ownership system in BCCH system, where you register a title, get a deed, and legally own your land, the judge says Aboriginal title exists outside that system and above it. And Richmond isn't alone. A similar ruling recently came down for Haida Gwaii, recognizing Aboriginal title over extensive portions of the archipelago. Property owners there are equally terrified. See the pattern? These aren't isolated cases. They're part of a wave of Aboriginal title claims that could eventually cover millions of acres across BC. Much of it privately owned. BC Attorney General Nikki Sharma was at that October 28th meeting, but she wasn't given speaking time. In interviews, she's tried to reassure property owners, once you have a fee, simple title in BC, it has to mean that those boundaries of that land is your land. We're taking this incredibly seriously. But if the government is so serious about protecting private property, why did they lose this case? Why didn't they argue for extinguishment like Richmond wanted? And why are they refusing to take it to Canada's Supreme Court for a definitive ruling? Section 5. Before we wrap up, comment below with your thoughts on this. Should Aboriginal title override private property ownership? Or should the government have extinguished these claims a century ago? Let me know. Here's where this case goes from here. 3 separate appeals have been filed. 1. BC Provincial Government, appealing the ruling. 2. City of Richmond, appealing the ruling. 3. Cowichan Tribes, appealing to expand their claim from 750 acres to 1,846 acres. Yes, you heard that right. The Cowichan aren't just defending what they want double the land area. These appeals will go to the BC Court of Appeal first. That process alone will take years. Then, regardless of who wins, it will almost certainly go to the Supreme Court of Canada. We're looking at 2028 or 2029 before there's a final decision. If you're a homeowner in the affected area or anywhere in BC with similar claims, here's what you need to do immediately. 1. Document everything. Keep all correspondence from the city, province, and your lawyer. This is evidence if you need to sue for compensation. 2. Contact a real estate lawyer. Do not try to handle this alone. You need a lawyer who specializes in Aboriginal title cases. 3. Reach out to Attorney General's office. Niki Sharma's team is collecting information from affected property owners. Tell them your story, especially if you can't get financing or your property value has dropped. 4. Don't panic sell. Your title is still registered. You still legally own your home. Yes, there's uncertainty, but rushing to sell at a loss might not be necessary. 5. Join with other owners. There's strength in numbers. Homeowner Kalmatu said he's planning his own lawsuit. Consider joining group legal action. This case has become a major political flashpoint. John Rusted and the BC Conservatives are using it to attack IBI and the NDP. Rusted demanded an immediate pause of ALL negotiations with First Nations until the Supreme Court weighs in. The First Nations Leadership Council called Rusted's demands disturbing and said it would only exacerbate tensions. They insist Aboriginal title and fee simple ownership can coexist. Both sides have legitimate concerns. Indigenous peoples were here first and never signed treaties surrendering their land in most of BC. But homeowners who bought property in good faith shouldn't be collateral damage in resolving historical injustices. If you're a BC homeowner watching this, I know this is scary. The idea that property you've owned for decades might suddenly be subject to competing Aboriginal title claims is terrifying, and the government's response has been inadequate. But here's what I want you to understand. This isn't about blaming Indigenous peoples for asserting rights the courts have recognized. And it's not about blaming homeowners for buying property that the province said was legally theirs. The blame lies with government, provincial and federal, for failing to resolve these land questions over the past 150 years. There is a path forward. Fair compensation for homeowners whose property values drop. Negotiated settlements that respect both Aboriginal title and private property rights. Legal clarity from Canada's Supreme Court about how these interests coexist. Like this video if it helped you understand what's happening. Subscribe for updates as this case progresses through appeals. Share this with anyone who owns property in BC. They need to know about this. And comment below. Are you in Richmond? Are you worried about Aboriginal title claims in your area? What do you think is the fair solution? I read every comment.